Hello, welcome back to Questions That Matter, where we discuss all of the interesting and exciting work that we are doing at TrustBridge. In an op-ed that she recently wrote, my colleague Natasha spoke about the new data protection law and the provisions in that law for disputes to be settled at the TDSAT, or the Telecom Dispute Settlement and Appellate Tribunal. She pointed out certain flaws with how those proposals might work, and we're here to talk to her about those today. Natasha, congratulations on the op-ed.
Thank you.
So let's first lay the ground out.
Sure.
Right? Take us through this. What's the proposed mechanism here? How are disputes supposed to be settled under the new law?
So we have a new data protection law, and the data protection law sets up a data protection board, which is going to hear disputes and handle disputes. And there is an appellate mechanism that the Act has set out, and that has been further elaborated upon in draft rules. So what the law says is that all appeals from the Data Protection Board will go to the TDSAT. These appeals have to be filed in digital form, and the TDSAT has to dispose of these appeals within 6 months. Now, all of this sounds great, but the question is this going to happen? Is this an implementable sort of framework that the law has set out for us? And my sense is that it is not. And I think that the TDSAT has certain bottlenecks and certain limitations. And without the 3 reforms that I've proposed in that piece and that I will talk about, it'll be pretty difficult to see a disposal of these appeals.
Okay, so I think that's intriguing because, as you said, on the face of it, these proposals sound good. You have a data protection board under the law that will take decisions. If somebody has a problem, then they file an appeal before the TDSAT. So what's wrong with that? What are the problems and what do you propose in your op-ed?
So 3 things, right? One is that all tribunals must have technical members. And the reason for a tribunal to exist partly and for them to have a technical member is so that there is some sort of sector-specific expertise when hearing those appeals. So for telecom-related appeals, there is a technical member who is well-versed in the telecommunication space, broadcasting, etc., on the TDSAT. But we're not seeing anybody who has expertise in data protection. So issues of privacy, issues of consent, transfer of data, all of the issues that the data protection law raises, somebody needs to be equipped and an expert in these areas. And we're not seeing that currently on the tribunal composition. So that is one key change that I think needs to happen. The second thing is that, so they are supposed to dispose of these appeals within 6 months. But the question is 6 months realistic? I went back and looked at 5 years of pending cases before the tribunal, and I looked at this in February, and I looked at this today. Over the course of 5 years, from February 2020 to 2025, there are about 3,400 cases pending. And from until now, we have about 3,500. So it's only increased. We're not seeing them dispose of any cases. The pendency is increasing. So this brings us to the question of how are they going to dispose of these appeals within 6 months? The third thing is just some organizational changes or technological updates that they need to make. These appeals need to be filed in digital form. And appellants should be able to easily track where their case is, when is the next hearing, etc. And unfortunately, the TDSAT website does not instill confidence. And I expect that it will need to be significantly updated in order to keep up with the data protection appeals.
Those are some pretty compelling arguments, I'd say. And I just want to quickly recap these because each of these is important for different reasons. As you said, the reasons for setting up tribunals, aside from reducing the load on courts, also includes the inclusion of technical expertise in the decision-making body. And today, the TDSAT may not have any members who understand the intricacies of the data protection law, and therefore the tribunal currently may not be equipped at all to handle those. That's one. That's a question of technical expertise. And then we also see from the numbers that you've pulled up that there's a staggeringly large number of matters that are being brought before this tribunal today anyway, and the pendency is only increasing, adding one more set of matters is only going to make the problem worse.
And what has already made the problem worse is that there is a new Telecommunications Act of 2023. So appeals under that will also go to the TDSAT.
And so in some senses, we're back to square one. We said that, look, the courts are getting overwhelmed, and so therefore you must have specialized tribunals and take this out of the court system, will speed things up. And now that very same tribunal is getting clogged up as well. And so perhaps this particular proposal that we're talking about under the data protection law may not be the best way to achieve the target of resolving these appeals within 6 months, as you pointed out.
Absolutely. And interestingly, previous proposals on this data protection law and its appellate mechanisms didn't involve the TDSAT. So initially, they considered setting up an entirely new tribunal. They also considered having the appeals filed before the High Court. So those were things that were considered. And I'm curious to understand why they landed on the TDSAT.
Sure, because as you said, the third limb which the Act requires is adopting, shall we say, certain procedural technologies to ensure that the first two objectives are achieved. But the way things currently stand, we're not sure if that is in fact realistic to expect from the tribunal. Great, but let's say some of this happens, some of this doesn't. How do we find out? How do we ensure that there is some accountability at the tribunal?
You're right, accountability is very important. And one way I think of ensuring accountability is having the TDSAT publish annual reports. Now, this is not a legal requirement, it's good practice. The annual report could contain information on how many appeals have been filed, how many are pending, how many have been allowed, what area they relate to. So have they come from the Telecom Regulatory Authority, or have they come from the Data Protection Board? So a lot of these details will be helpful. Otherwise, you'd be like me and have to navigate the TDSAT website to figure out how many cases are pending. So an annual report would be a great way to ensure accountability.
Fantastic. Thank you. I think it bears saying that very often as people analyzing regulatory performance or how tribunals are working, we're looking at things that originated in the past and the problems are manifesting now. But we've got the opportunity here. There's a new law, appeals haven't started going to the TDSAT yet, and so there's an opportunity to preempt and prevent these problems. And so I think the insights that you have and the solutions that you proposed are very, very timely, and we certainly hope that these are things that are considered so that these problems do not arise at all in the future. Thank you very much. If you've been watching all this way, you're probably interested in what we're talking about. And if you are, then the best thing you could do is to like this video, share it with other people who you think might be interested in it, subscribe to our channel, and smash that bell icon. Thank you for watching.